docket. That is case number 106299, State of Kansas v. Bobby D. Edwards.
Good morning. May it please the Court. Carol Longenecker-Schmidt of the Appellate Defender Office representing Mr. Edwards. If I may, I would like to request 3 minutes for rebuttal.
3 minutes is granted.
Thank you. Unless Your Honors prefer otherwise, this morning I would like to focus on the first issue in the brief, the sufficiency issue, and submit the remaining issues on the brief. This sufficiency issue really contains three sub-issues on sufficiency. So within this large issue, I will begin focusing on the question of whether a taking that is merely incidental to the commission of another crime is sufficient for robbery conviction.
And why don't you start off by pointing us to the statute, the robbery or aggravated robbery statute, where there is a basis for finding an exclusion for incidental taking.
I think there are two ways you can approach this question. One would be to read into the statute a specific intent, which is admittedly a difficult argument to make.
You would agree with that? It's a stretch.
I don't know that I would use the word stretch. In order to do that, we'd have to find the language to be ambiguous. And I think that's difficult to argue. However, this court in the past has read more into the word take than is just there by plain reading, such as, for the example, in the case of the kidnapping statute, where this court in the past read that taking is more than something that's incidental. So that would be one example, or one argument why we could read more into the word take than just an ordinary definition of taking. Another approach to go on this would be to move away from specific intent and focus on general intent.
Excuse me, counsel, before we proceed, bailiff, will you ask the gentleman in the rear, I think counsel also, to move their discussion to another place? Either you or the officer. I'm sorry, counsel, please proceed.
So even if this court decides that there is no specific intent to permanently deprive the owner of his or her property within the robbery statute, I think we can just focus on the general intent to take by force. And I think that where the taking is merely incidental to the commission of another crime, there is no intent to take by force. And when I'm talking about taking by force, I'm applying the general intent to not only the taking, but the force. Or in other words, the force must accomplish the taking. And I think that this interpretation or this view of general intent is consistent with this court's holding in Thompson in the past. This court held that all that is required is a general intent to take with a threat to do bodily harm or by force. And the wording in that case did not apply the general intent to just the taking, but linked it also to the force.
Excuse me. If the legislature defines a crime low level, a minor crime, and then gives it a severity level 5, a substantial penalty, is that an ambiguity?
Could you I'm not sure that I understand your question, Your Honor.
Right. Well, if an incidental taking constitutes a robbery, and that's a minor criminal act, and then the legislature gives this minor criminal act a level 5 severity level, a high level for a low offense, is that an ambiguity?
I suppose that could be an ambiguity that could indicate that the legislature meant something more than a simple taking by assigning it a high severity level or a severe severity level. So I think that could be an argument for ambiguity, which would take us to the next level of statutory interpretation. So I could continue to address specific intent, or I could move back to this general intent argument. Either way, Your Honors prefer. But regardless of which direction you go on this, the case law that I'm asking this court to rely on is that a taking that merely facilitates another crime is not sufficient for robbery. And that's what we had in Montgomery, and that's what we have in this case here.
How do we have it here when you're suggesting that we focus on the general intent of taking by force? Given the facts of this case, there's lots of force here. Wouldn't you agree? I mean, I don't want to read too much into what occurred, but this was a violent struggle, and including the victim getting hit in the head with a hammer, and her wherewithal is one probably at least saved even more traumatic or perhaps fatal injury. But how is this not a forcible taking?
There is certainly evidence of a lot of force in this case. However, I don't think there's evidence that Mr. Edwards intended for that force to allow him to take the phone.
How can you say that when that's what started this whole encounter, was the use of the phone?
I think that if his intent was to take the phone or for the force to result in the taking, well, he initially took the phone, or Ms. Zenner handed him the phone, and he dropped it in his pocket. At that point, he could have, if his goal was to take the phone, he could have left with the phone, but he didn't. Then he picked up this hammer and hit her several times. And then the second taking, or the later taking, the evidence supports that he took the phone as she was dialing 911, or in order to prevent her from calling 911. Not necessarily,
But under a sufficiency argument,
yes.
isn't there some evidence in which a reasonable jury could conclude that at least one of the motivations for the encounter was so that he would have a phone to use after the encounter? I mean, he may have had other intentions as well, but wouldn't we still have sufficient evidence that he intended to take the phone?
I think that the fact that he left the phone in the neighboring apartment, that he didn't walk away with the phone initially when he had it, is evidence that he did not intend to take the phone.
Sounds like a jury argument, but going back to our standard of sufficiency, why do we not have sufficient evidence of an intent to take the phone?
I think you would just need something more. It could be a jury question, but I think that you would need something more. My interpretation of the evidence is that all the evidence was that he intended to commit an aggravated battery, and that the taking of the phone was merely incidental to committing that battery. And because it was incidental, he didn't have an intent for his force to accomplish the taking of the phone.
Do you have any further presentation for us, counsel?
I see that I have a little bit of time remaining, so I think I'll just address one of the other sufficiency issues, the issue of whether the force preceded or was contemporaneous with the taking. And the Court of Appeals in this case concluded that while the force didn't precede or was contemporaneous with the initial taking of the phone, there was a second taking later on, and that force was contemporaneous, or he forcibly took the phone. My argument here is that there were several takings, or two takings, and there was a unanimity instruction given in this case, and I'm not making a new multiple acts argument here. I'm simply clarifying that the Court of Appeals couldn't have known which taking the jury relied on.
How can you argue it doesn't apply to incidental taking, but it applies to consensual transfer? I mean, she gave the phone to him initially, so how could that be an act of robbery? If robbery doesn't apply to incidental takings, it certainly doesn't apply to consensual transfers. So, go ahead.
I don't think that it does. However, in this case, the jury did not get the instruction that the force needed to precede or be contemporaneous with the taking. And so under the instructions in this case, the jury could have been saying, well, there was a taking, and then force occurred, and in their mind, maybe force afterward was good enough to accomplish a taking by force.
Well, that's an instruction challenge. But why does it affect the sufficiency?
I think the two questions are related. There's a lot of overlap in the issues in this case. It affects the sufficiency because that instruction was not given. This court can't determine that there was sufficient evidence for each taking. In the eyes of the jury, they could have viewed that first taking of the cell phone as a taking under the robbery instruction. And so therefore, we don't have sufficient evidence for each taking.
And we need that for multiple acts? That's an alternative means requirement, that you have evidence of each of the alternative means. If you're saying these are multiple acts, all we have to have is unanimity of which act.
Election or instruction.
Right.
Sorry, I didn't.
Election or instruction, which you're saying.
Right.
now.
There was no election, and
But there was an instruction, wasn't there?
Yes,
Isn't
Your
that what you
Honor.
just said?
yes, there was an instruction. I'm saying that that there were some takings that there was insufficient evidence basically for each taking for different reasons. And the Court of Appeals seems to be focusing on the second taking here, saying, well, there was sufficient evidence of this second taking, which I disagree with. I disagree that there was sufficient evidence for both takings, so I apologize if I made that unclear.
Right, you're saying for both.
For different
We just
reasons, I think.
established that the first one was actually consensual transfer, right? She handed him the
Yes.
phone the first time, so that wasn't taking at all. So the taking of the phone, at least, was the one that was accompanied by, as I think you characterized it a moment ago, lots of force.
I think my argument is that legally the handing of the phone was not a taking. However, the jury could have viewed it that way because of the nature of the instructions.
Okay. Even with the unanimity instruction.
Yes, that's my belief, Your Honor.
Okay, thank you.
One quickly on another issue regarding the applicability of 6226B6 in the expert testimony notice. Wouldn't you agree that that statute is incompatible with criminal procedure? I mean, part of that statute requires like a 90-day notice, and that some of these trials based on speedy trial are required to be held within 90 days. The state or even defense is not going to know who their witnesses are going to be prior to 90 days. It just doesn't seem to me to be a very good fit for you to rely on.
There may be portions of that statute that are not particularly practical. I think the underlying principle, though, that the state needs to notify the defense of expert witnesses is applicable here to allow the defendant opportunity to prepare to confront the witnesses against him.
Isn't there a provision that requires the state to endorse all of its witnesses on the complaint? And why isn't that specific criminal statute take precedent over the civil?
I think the civil statute specifically here mentions expert witnesses, while the
Well,
statute...
I understand that, but as far as notification, the criminal code includes a witness notification requirement on the state in that you have to endorse the witnesses on the charging document and supplement it for the defense. And why isn't that sufficient notice? And then the defendant can file a bill of particulars, or you can ask for the normal things you would get from a expert witness if that applies. But
I think that the civil statute provides more protection for the defendant, provides more specificity about the type of witness and the type of testimony, and better protects the defendant's right to confront the witnesses against him.
And what's your gateway to get to the civil code when 6201 says this code applies to civil actions and proceedings in district court?
My best gateway there is that I think the statute is more specific than the previous statute that was mentioned, because it relates specifically to expert testimony, and where a statute is more specific, that statute controls over the general statute.
Even if the prefatory statute says it only applies in civil actions?
Yes, that would be my argument.
Any further questions of counsel? Thank you, counsel.
May it please the court, Assistant District Attorney Matt Maloney on behalf of the state. I will be happy to answer any questions about the other issues, but I also plan to focus on issue number 1, and specifically the incidental, the timing, or the Montgomery issue, essentially, as to whether there had to be proof that this wasn't simply incidental to another act. In its opinion, the Court of Appeals, I feel, did a very good job of analyzing the Montgomery opinion, and also citing to this court's opinion in Thompson. And I also addressed Montgomery in the brief and explained why my position was that it did not apply. First of all, I think, as Your Honor pointed out, I think the starting point has to be the language of the robbery and aggravated robbery statutes themselves. And very clearly, they do not contain language indicating that it has to be, that there's an intent to permanently deprive. And the statutory language controls. And as this court indicated in Thompson, we can't read any more into that. And that is the major flaw with the Montgomery opinion, is that the Montgomery panel very clearly did read language into the statute that does not exist. I think it's telling that in the 14 or 15 years since Montgomery, that case remains, at least as far as I can tell from a published opinion standpoint, it remains an outlier. And I think there's good reason that no panel has followed that since with a published opinion, because it does add statutory language that is not there. So when you're looking at the statutory language, the defense argument really has no traction. As to counsel's argument with respect to the general intent, and that that there has to be intent that the taking was by force, that you look at the force itself and whether there was an intent to take by force. I'm not sure that I fully understand exactly what counsel's arguing here, although I would note, as Your Honors have, that in this particular case, there can be little doubt that there was a substantial amount of force that was applied. He hit her over the head multiple times with a hammer. He also threatened the victim and her son before he ultimately took the phone back from her following this struggle. So very clearly on the facts of this case, even if somehow the theoretical argument raised by the defense were to gain favor with this court, in this particular case, the facts are so strong that there was a substantial amount of force applied before the taking, that the defendant's argument would not afford him relief in this case.
I see your argument, and I understand that perhaps Montgomery went too far, but how insignificant or slight can the taking be to satisfy your argument? Let's say there's a shoving match or something, there's a fight or just some sort of shove. I grab somebody's sweater and a button comes off, and then I take off. That's an it's a taking by force. It fits the robbery statute. It's incidental to the crime. It's an incidental taking to the crime. Is that a robbery? And that's my, I guess my only hesitation is maybe not our worry or bother, but it does seem to allow for insignificant, or rather criminally insignificant acts compared to robbery anyway, to convert that act into a robbery.
I think in that hypothetical, I think that would probably be a jury question there to determine whether they think that the force was sufficient to meet the statute, and whether
it's more the taking. I mean, it was kind of, it was unplanned. I did this, I grab him and button pull, and I take it.
Well, I think, again, looking at the language of the statute, the strict language of the statute, I guess in that scenario it would then depend as far as taking. In your hypothetical, you're saying that you then do actually take
It's the slight or insignificant kinds of things. This could, perhaps this interpretation could broaden the statute probably beyond its intent.
Right. Well, certainly that hypothetical obviously is significantly different from what happened in this case, and I think Your Honor probably is on the right.
But you can't ignore you can't ignore the consequences of expansive interpretation, can you? And you can't ignore the fact, as Judge McQuinn said, this is the severity level 5. And you have the rule of lenity when it comes to construing penal statutes, and you have to have some sense of fairness here to grab a pencil out of your schoolmate's hand and you go into prison for aggravated robbery.
Well, I think the argument, my response to that suggestion would be, the suggestion was that, well, this takes what would otherwise be a relatively minor crime, an incidental taking, and makes it a level 5 felony. But I would point out that you still have to have the element of force, and when you're taking something by force or threat of bodily harm, then I would disagree with any characterization that is then a minor offense that is given an extreme severity level. Maybe the fact that it was taken in these hypotheticals, that something was incidental, be that as it may, it still requires force. And I think anytime you apply force or threaten somebody in the process of that taking, then I think that takes us a long way from saying that that's just a minor offense. That would be a good explanation for perhaps why the theft statute does expressly require that it be with the specific purpose to permanently deprive. But when you're talking about the robbery or aggravated robbery statutes, you already have the element of force and or threat of bodily harm, which I think far removes us from a situation where somebody simply incidentally takes something without these elements of force that make it a more severe crime.
That answers that question, but I want to take you back to Justice Rosen's hypothetical. Is there some threshold of taking, assuming force? In his hypothetical, I think there was a fist fight or something like that. Button pops off, the defendant sticks it in his or her pocket and runs away.
You're asking if there's a threshold as far as the amount of force?
I think he said it would be a jury. Yeah, the force is there.
Sure.
We're not talking about force here. I'm not talking about level 5 severity or you make a good response to why it still fits the severity level because of the force aspect. But let's assume force. The taking is just insignificant. That could be prosecuted. That's what you're saying is a jury question?
I do think that would, I think under the statute. Now, I think the fact that we don't see many cases like those, we don't have any of those in the case law that I found, I think that's a good sign that there's prosecutorial discretion that is largely going to act as a check on that type of thing. But I think...
But what's a jury going to decide? You say that's a jury question. Putting aside jury nullification because it's a ridiculous prosecution, what does the jury decide? How does that make it a question for a factual question for the jury? What's the facts they have to determine to rule that or give a verdict of guilty in that scenario?
Well, the jury, they still would have to find, and I know this doesn't go towards the taking aspect of it, they would still have to find that there was a sufficient level of force that was applied. As for the taking itself, I guess if the defense is not able to present, if the evidence is uncontroverted that the defendant did take something and keep it, then perhaps there's not much of a question, although I would note that we've all seen plenty of cases in which the evidence seems to be overwhelming and the jury does end up acquitting a defendant. So there's always room for a jury to render a verdict that might not seemingly have any.
But that's not a jury question. That's a jury nullification if you have overwhelming evidence. But we're back to what is the question here. Do you have to have, even if it's general intent, do you have to have an intent to take the property?
An intent to take the property, yes, and it doesn't have to be intent. I think even in that hypothetical, maybe the intent was not formed before the person came into the house, before he got in the scuffle, but at some point under the hypothetical, it is formed. Maybe in that scenario, you get into a pushing and shoving match, you grab the person's sweater, the button comes off. At that point, you obviously have the opportunity to decide whether you're going to take it or not. The button could come
Yeah.
off and you leave it there and you haven't committed a robbery. So,
But you've taken it from his person.
correct.
And the way I hear you arguing is if property is taken, like I snatch that cell phone, even if I throw it down, that's a taking. In your expansive definition, that it doesn't matter if it's incidental to the battery or incidental to the scuffle, if it's taken from their person under the strict language of the statute, then that's a taking.
Well, I think first of all, I'd point out, I mean, it's not my definition, it's the legislature's. And so to an extent, whether I agree with it or this court agrees it or anybody agrees with it, there are all kinds of statutes that any number of us might take issue with and say could have been drafted differently or better. And that's really not for us to decide to some extent. It's if the legislature has criminalized it, then even if we disagree with it, we do have to live with the language of the statute. I guess, as to the hypothetical, and again, obviously I'm thinking on the fly here as far as just the removal from the sweater itself, even if the person doesn't take it, would that constitute a robbery? It's so far afield from what we're dealing with in this case that I certainly wasn't prepared for that type of a hypothetical, but
It's far afield, but what you're asking is how what I'm looking at is how broad does this statute then become without Montgomery, and it does seem to include any insignificant or minor type of possessory control over the property. That's fine. That's maybe what the now the robbery statute would read, but that's what it would do.
Right.
Is what I'm trying to get a handle on.
And I think it is one of those situations where there is no. I think to answer the bottom line question, I don't think that there has been any threshold established in case law that I'm aware of that tells us. I think that the cases that are cited in the briefs, Montgomery and Thompson, really reflect the state of the law on this issue.
I believe Montgomery was a pair of glasses, or some glasses that was taken during a sexual assault.
Right, and I would note, to distinguish Montgomery from our case here, a key difference is that in Montgomery, I think the evidence shows that the defendant took, quote unquote, the glasses, but then he essentially left them at the scene, right there, which showed that he had no real interest in the glasses themselves.
Not right there. I guess I'm sorry, I have an advantage. I was a trial court and heard the evidence. They were nearby, but they weren't right there, and the victim was left, would be like I would be if somebody took my glasses, unable to find them. I mean, for her, they were in essence, gone, totally gone. So
I still think that's a little different than in this case where he took the phone completely out of her apartment, left it at, I believe what the record shows is that it was the vacant apartment next to the defendant's apartment. So he's completely removed it from the scene. And I think more importantly, perhaps, is the fact...
that's not totally different. If the glasses are taken to prevent the victim from being able to see, to pursue, to get the glasses, I see that's real comparable to taking a phone to keep the person from calling the police to catch you. I mean, it's you've taken it, but you didn't have the intent to take the property. You had the intent to prevent something.
Prevent detection.
Right.
Well, I think that the other difference is I think when you look at this case, it's very evident that he was focused. I think there was some argument by counsel today indicating that he really wasn't focused on the phone that much. He didn't really care too much about getting the phone, because if he really cared about the phone, why didn't he just leave the apartment as soon as she gave it to him the first time? And I think I have two responses to that. I think he didn't take it the first time, he didn't leave the first time, because I think he had multiple intentions when he entered that apartment. And so just because he didn't solely go there to take the phone doesn't mean that wasn't part of his, that wasn't a factor, that wasn't part of his intent. The second thing is, I would say his actions throughout the time in the apartment show that he was very much focused on this phone. He beat her over the head to prevent her from regaining control of the phone. So the phone was not simply incidental to what was going on here. The phone was a major focus of the defendant. It's what caused him to stay in the apartment, to beat her over the head with the hammer, to threaten her and her son. So while I think in Montgomery, and obviously I'm not as familiar with the facts having not been in the courtroom, but just reading the appellate opinion, it seems like there it truly was a situation where the glasses were just kind of incidental. He saw an opportunity to perhaps make it more difficult for her to identify him, and so he removed them a short distance, and I don't know the exact distance, but it was I think the opinion indicates nearby. Here, we're talking about removing the phone completely from her apartment, putting it in this vacant apartment that might be in the same complex, but I think that that's still a meaningful distinction between the facts of Montgomery in this case.
So you're saying, go ahead.
I was going to go back to an earlier issue, so why don't you proceed?
Well, I just wanted to clarify. So you're saying that we could affirm this conviction without the necessity of having to explicitly overrule Montgomery?
I think it's possible. I would ask the court not to do that because I do think that Montgomery is contrary to the statute. But I think it's possible, yes.
Counsel, you took some pains earlier to say that the robbery statute is not your statute, but it's the legislature's creation. If you could put on your legislative cap for a moment, how would you fix the statute to exclude Justice Rosen's hypothetical?
Let's see, looking at the current language of the statute. It's an interesting question because it currently is defined as taking of property from the person or presence by force or threat of bodily harm. I don't know if there's a way to... I think in that hypothetical, I guess there is a legitimate question in that scenario as to whether that's really a taking of the property. It's been removed from the person's clothing, but taking, I think, implies that the defendant himself then receives possession of it at some point. And in the hypothetical where the person pulls the sweater, the button comes off, but then the defendant never himself takes the button and the button just falls off the sweater to the floor and is left alone. I don't know that the defendant ever in that situation has taken the property. It has perhaps been damaged to property. So I don't know that it's necessarily, as I look more at it, I don't know that it really would be necessary to fix the statute to avoid a robbery prosecution in that case, because I don't know that the defendant has taken the property. It's simply damaged. It's certainly damaged the person's clothing, but I don't know that that would fit even under the current definition of the robbery statute. So
if the button had not simply fallen to the street, but when in this scuffle, let's call it a violent struggle, the defendant grabs a hold of the shirt, gets a handful of shirt, rips it, has a button on it, and then after the fight is over, walks away. Yeah. The defendant notices, oh gosh, I got a big handful of material with a button attached, and throws it away within a minute to the scuffle. Is that a taking under the statute?
That's a closer call, I think. If he did have it. I think even there, I think the question would still be that might not even be enough for the general intent because he didn't know that he had it, and he did, in that scenario, immediately discard it upon realizing that he had possession of it. So I think even under the general intent, there would be a way to suggest that would not fit the robbery statute. But I certainly, I think I've gained a new appreciation for our legislature, and perhaps I shouldn't always be so quick to wonder about the wording of some of our statutes. But to answer your question, I do think that in both of those hypotheticals that the current statute itself would probably be sufficient to address those types of concerns.
I have another hypothetical. Let's say in a situation, domestic violence, man batters his wife, wife grabs her phone to call 911. He takes the phone from her to prevent the call. Is that a robbery?
Well, under the language of the statute, I guess first we'd have to go into what type of, whether he uses force. In that scenario, simply grabbing it from the person, I guess, would probably qualify as force, because it would not appear that she'd be in that scenario, relinquishing it voluntarily. So there would be force applied. I think it's a close call. I think he clearly took it. If it's her property exclusively, I think that's a close call. I think it could be. I off the top of my head, I think that probably that would qualify as a robbery. And I guess in that particular scenario, I wouldn't feel conflicted about that being considered a robbery in that scenario, where he is violently by force taking her property from her. He does clearly in that scenario have the intent to take it from her. So I think that probably could qualify under the statute.
Another question, was the jury instructed regarding aggravated battery?
In the final trial, because aggravated robbery was the only charge that was remaining on the table, I don't know that there was any type of a battery instruction given at that particular trial.
Do you know if it was in the first trial?
In the first trial, he was charged with murder or with attempted murder, I believe, and aggravated burglary and aggravated robbery. I am not certain whether an aggravated battery instruction was given in any of those. I don't know if it was instructed upon as a lesser, perhaps. The record obviously will reflect one way or the other. It certainly would seem logical to some extent that it might have been considered as a lesser of a crime, but I'm not certain because the issue was never raised. I didn't review the record specifically for that issue.
Do we have any further questions of counsel? We've peppered you with a lot of questions. Would you like 30 seconds to wrap up?
I don't think I'll even take that amount, Your Honors. I think again, the focus being on the one sub issue of issue 1 today, I think that the Court of Appeals in this case did an excellent job of distinguishing Montgomery and also pointing out its inherent flaws. I would ask this court to rely on the language of the statute, rely on the Thompson opinion, and to, for those reasons, affirm the defendant's conviction.
Thank you, counsel.
I will just briefly suggest that perhaps one way to fix the statute would be to do what this court did with the kidnapping statute, which would be to hold that the taking could not be slight, inconsequential, and merely incidental to another crime. Could not be the kind of crime, the taking must not be the kind inherent in the nature of the other crime, and must have some significance independent of the other crime. That would be one way to approach this. The jury could be instructed on that, and they would have to make that factual determination then about whether the taking was incidental to the other crime.
Which was what your position was at trial, essentially.
Any further presentation?
No, Your Honor.
We have any more questions of counsel? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. The court will take this matter under advisement.